refresher course. And Chris, if you want, tell me when you're ready for me to shoot forward, and I will, but that's our focus today.
All right. Well, and I would like to introduce everyone to Aaron Evenchik here. I've gotten to know Aaron here over the last few years. We've become more familiar with Honlosier. And Aaron's been dubbed a zealous and creative attorney by opposing counsel, and he specializes in construction and real estate law. He has first-chair experience in construction and contract disputes, as well as asserting lien and bond claims. Degree in civil engineering, which makes him a good guy in my book, and experience working in-house with a construction company. So I'm going to turn it over to Aaron for today's presentation.
Great. First, I want to thank Chris, you for letting us present today in the OCA. You know, Chris has been instrumental in helping OCA members. Chris and I are working on a matter right now together. We're trying to get things resolved. And whenever I call, Chris immediately picks up the phone, and I appreciate that. I want to thank Aaron Hawk, who none of you can see and is working in the background and helped to get everything together for today. I know a lot of you who are on the call because I got a list in advance, so I want to say hello to all of you, many clients and friends on here. So hello on this rainy Friday, and let's have some fun talking about lien and bond claims. First, we have this great construction law blog, constructionlawinsights.com, where my postings and postings of members of the Honlosier team are put up regularly, so it's a great place to check. Take your time to go through that. For those of you who don't know who I am, there's a picture of me a little bit younger. I focus on construction claims, real estate and zoning issue, general business. I've been doing it for about 20 years, and I'm at home. I'm a dad with my wife and 4 kids. I haven't been in the office in all those days, and I know a lot of you are working from home as well. So the focus today is going to be on how liens work and bond claims work, what we need to do to perfect those, what we need to do, because I know a lot of you are sitting in the position of the general contractor often on projects, to defend against those, understanding the difference between public and private. And I know if you're OCA members, and again, knowing who many of you are, that you focus more on public work than private work, but we're going to talk about them both so you understand how the law works, some of the bond and surety claims and enforcing those things, or defending those when you have a claim made against you. So that's what we're going to talk about today. One of the first questions is why put a lien on, or why a lower tier might put a lien on? Well, a lien secures payment, meaning let's talk about a private project to start with. Imagine there's a private project. There's a grocery store that's being built around the corner from me. And a number of our clients were on there. At the end of the day, that grocery store chain went out of business. They went and put a lien on. What did that give them rights to? It meant that when the lender, who had the first and best lien, that mortgage, went and filed suit, that lender had to name all of them in the litigation. It gives us a seat at the table to help negotiate, even if there wasn't equity. And it enabled us to say, look, Mr. Lender, you're selling this, you're taking a hit, we're taking a hit. We want X cents on the dollar, you can have a greater number. It gave us a seat at the table to negotiate. Had our client simply said, well, there's no point in doing a lien, there's no equity in this, the lender's going to get it all, it would have gone and they would have had no voice or no ability to negotiate. Another thing to do on liens, and we see this on public projects, especially where there's a disputed lower tier claim, is sometimes that lower tier will file a lien for the full value of the claim. So for example, if you're building a building and the roofing contractor, subcontractor says, there's a problem, here's what it is, it's a $500,000 claim, and you, the general contractor, pass it up to the owner, ODOT, perhaps on the project, you're building a maintenance building, and ODOT says nope, you go back and tell the lower tier nope, tell the lower tier make your appeal in strict accordance with project contract documents, and an ODOT one will go through the step process, but that roofing contractor finishes the work while that process is going on, they might go put a lien on for the full value of their claim. So that suddenly slows payment to the general contractor. So, and if you're the roofing subcontractor, I'd tell you it's a great idea. If you're the general contractor, it's not such a great idea because it slows money to you. In all of these cases, the lien law is dictated by statute, and you've got to strictly follow it. If you're late, you lose. I got a question from another lawyer yesterday, and they asked me, Aaron, during the shutdown, have lien dates been extended out? So if you're late, it's okay. And I said, well, I wouldn't count on that. I'd make sure you get your lien done timely. And if you have a client calls you who's late, then you can make that argument. So at the front end of any project, whether public or private, you want to always be able to know your tree, your contract tree. And if I was with all of you live, I know I've done this before with some of you live, we would draw out the tree. And this is the first time I've done that. So on any of these, you always want to know who is where and where the money is coming from. And I'm drawing the tree. Hopefully you can see it on your screen right now as I draw it.
Aaron, unfortunately, we don't see it. Oh, there you go.
Don't?
Yeah,
No,
there
now
we
you
go.
see it? Great.
Yeah.
Great. So you can see this sort of contract tree is going to be so important on any project to understand. Now, I know a lot of you are the general contractor, so it's an easy tree to draw. But on a private project, oftentimes you perceive you are the general contractor because you've signed a contract with someone you believe is the owner, but that's not always the case. If you were doing private work, it's a good idea to check and see who the owner is. Go onto the county recorder site and see, am I indeed signing a contract with the owner? Because if you're not, that might trigger your requirement to have to file a notice of furnishing. And we're going to get to that. And I know this is review for a lot of you, but it's helpful to go through and understand why the law is the way it is. So you will always want to, on a public project, this is easier. On a public project, the owner, here, I'll go up here if I can modify that. Public owner, there's always a pot of cash, right? That's what you lien on a public project. You lien that private owner's pot of cash. And at the beginning of a project, if you're on a public project, when you sign the contract, that public owner at the end of the contract has a finance officer certificate confirming that the money is there to pay you, and that's important as well. If you're ever working for a city, ODOT gets it right, but if you're working for a city that doesn't really know what they're doing and they fail to have that finance officer certificate, that city now has an argument that their contract is voidable and they don't have to pay you anything. We've had issues before where contracts were entered into incorrectly. The City of Fremont versus Truco Construction. Truco Construction was out there building a reservoir. Truco Construction was terminated. Litigation ensued. Truco said we're entitled to more money. One of the owner's defenses out there was, well, Truco, your contract was let incorrectly. Rather than have two readings of city council, meaning the first reading of city council, whereas we need a project, the engineer is authorized to go out and get bids. So the engineer could get bids. And the second one, whereas the engineer did bids, whereas Truco is the lowest, the engineer is authorized or the mayor is authorized to contract with Truco. That second one never happened. And the owner's argument was because that second one never happened, your contract's void, we don't owe you any money. And in fact, the law arguably is on the owner's side. The law is designed to protect the taxpayers. And that's what we're going to talk about. What the law is designed to do, it's going to help you remember how to do it correctly. The law is designed to protect the taxpayers, and if you don't have all the required public readings, taxpayers haven't been protected, and therefore we risk paying something out that shouldn't. So again, if you do have questions as we go, I know the chat bubble, as Aaron just lets you know, is active, and when I see a little red dot, I will jump on that. So you want to have, at the beginning of the project, know who everybody is, where the money's coming from. Imagine if this was a private project, that pot of cash wouldn't exist. On a private project, you get to lien the improvement. So we had a client as well looking to do, this was 2009, hot into the last time we were in a recession, the Great Recession. They were looking to build a mountaintop resort, and our client was going to put in a package plant, a sanitary sewer package plant at the beginning of the project. And it was a pay if paid clause. So we didn't get paid unless the general contractor got paid, no surprise. But the mountaintop resort was owned by a single asset entity. So our client said, well, Aaron, is this a good deal? And I said, well, here's what you got to think about. Number one, it's a single asset entity and all they own is that mountaintop project. Number two, the general contract doesn't have to pay you because it's pay if paid. So if you go and put that package plant in and then the economy continues to be bad and the owner of that single asset entity says, you know what, we're going to stop, and they don't pay the general contractor, you won't get paid. So you need something to protect yourself and guarantee you're getting paid. And we tried negotiating that. At the end of the day, the client decided, you know what, we're not going to move forward with it. The risk was too great. So on any of these projects, you always need to know who the owner is, where the money's coming from. When you're the general contractor on a public project, that risk is not as great, but certainly on a private project, knowing who the owner is, if it's a single asset LLC, do you have somebody who's going to sign personally, how much time do they have to pay you, have they tried to condition payment to you on their obtaining financing from a bank. All of these things are things to think about to make sure that you get paid, because that's why you all work as hard as you do. At the front end of the project, again, we've talked about making sure you have that tree. The notice of commencement on both a public or private project is going to detail who all the parties are. So on a public project, the notice of commencement is going to list the owner's ODOT. It's going to say who the general contractor is. It's going to list the general contractor's surety. And that makes it easy on a public project to know who you have to send your notice of furnishing to. On a private project, the notice of commencement is generally recorded, and that makes it easy to obtain. Sometimes it's not recorded, and you have to ask for a copy of it. And you can find these things online. Most counties have their own online record search. If you ever need help finding one, you can call us and we'll help you find it. So let me go back a slide. One of the concepts, I'm going to jump through here and put another box out. One of the concepts we're going to see is, pardon me, is who has the risk of double payment? Who takes the risk of somebody not paying the bill? Contractor. So let's draw a chart. My computer's not as fast as my hand. We'll contrast that, draw another one over here. This is the key to lien law, if you bear with me. So, on a private project, the owner has a building. The owner's name is on the notice of commencement. If the owner, we're going to write NOC, N-O-C, well, the notice of commencement will list the owner and will list the general contractor. On private projects, if a sub isn't paid, they put a lien against the building. So at any given time, when the private owner is paying the general contractor, the private owner obviously knows the general contractor exists because they have a contract together. But the private owner will not know whether a subcontractor or a subcontractor exists. They just know the general contractor exists. So what the law has done is said, private owner, you put out there a notice of commencement, and that will tell everybody who's working on your project you exist. Then all of the people who we don't know about can give notices of furnishing, NOF. So in this instance, on a private job, it is the general NOF, the sub and the sub who have to give a notice of furnishing, because the private owner doesn't know that they're there. So the sub and sub both send the notice of furnishing to the private owner and the general contractor to tell everybody in the contract train, I'm here. So that means for the general contractor, if they get a notice of furnishing from a sub, when that general wants to pay the sub, they need to confirm that the sub has paid the sub. Now, how do you do that? By getting lien waivers that show if you, for example, if you're the general contractor and you paid the sub through the end of April of last month, and now it comes time to pay for May, you want to get a lien waiver from the sub 2 tiers down that shows they were also paid in full to the extent you made payment. So again, on a private project, the risk of double payment is on the private owner. But on a public project, the public owner has a pot of cash. And when that cash is gone, that cash is gone. That's the private owner's or public owner's sole risk. In order to protect everybody, the law requires that the prime contractor have the surety. The surety in the bond is there to make sure that it promises performance to the public owner, right? So if the prime contractor goes out of business, the public owner tells the surety perform, the surety steps up, again, to protect the taxpayers, and it promises payment to everybody downstream. So who do we care about? Who has the risk of double payment on a public project? The prime contractor and the surety. Therefore, NOFs need to come from folks that the prime contractor and the surety or the prime contractor don't have a contract with. So here, that would be from a sub-sub. Because the prime contractor has a contract with a subcontractor, the prime contractor knows they're there. You don't need to get a notice of furnishing. Now, that said, this stuff's confusing. It took me that drawing to help explain it. Some of you might know this already. I tell everybody working on projects that unless your name is listed as the general contractor on the notice of commencement, you ought to send the notice of furnishing to everybody up the contract chain, including people who know you are there. So if you're, for example, a subcontractor on a public project, the people in our office doing this, hopefully they're on a call today learning it with me and you, but sometimes they're not. And so we have accounting clerks doing this who don't fully understand it and don't understand these exceptions. And so the exceptions really are there for when you call me and tell me, Aaron, I'm not sure we did it right. And I can say, don't worry, there's an exception. The advice, if there's only one thing you get out of this call today, it's you need to send a notice of furnishing up the contract chain at all times. It does two things. Number one, it's not adversarial, but it tells everybody I'm serious about getting paid, make sure that I'm paid. Number two, it protects the lien and bond right. And when you are the recipient, because I know many of you are general contractors, when you are the recipient of notice of furnishings, you ought to keep a list. I know some of you do for the project and have a spreadsheet that shows, okay, it's time to make May's payment. Do I have a waiver of lien from every lower tier that sent me a notice of furnishing for everything on April's payment? And those waivers of lien, they can reserve, and I know that project, it might not be retention, but if you're on another public project or private project and retention has been not paid because it's not due yet, so their lien waivers can reserve their retention amount as well, so long as the retention, it doesn't exceed what you're holding from their subcontractor, meaning the person above them. If the sub is owed $100,000 in retention, but the sub's lower tiers are owed $200,000 in retention, you know you got a problem you got to deal with. By doing this in real time, it means that if your sub runs out of town with the money, the biggest hit you'll take is a month or 2 months, 60 days worth. What we find are we get to the end of the project, there were notice of furnishing sent, the general contractors are making payments to the sub, but the sub hasn't been making to their supplier who sent the notice of furnishing, and suddenly the supplier says, I haven't been paid in months. And we've been paying, and in fact, the sub even signed lien waivers saying they're paid under oath, they paid their lower tiers, they're lying. So the only way to be sure is to get a waiver of lien from the lower tier suppliers you sent notices of furnishing. I don't see any questions in the box, so we'll keep going. So how do you get the, hold on, I don't know what I just did. I hit the wrong button, sorry. So let's jump to the next slide. So how do you get a notice of commencement? First, you ask for it. On a private project, via certified mail, return receipt requested. Why do you do that? You do that so you can prove service. You prove that you asked for it. You send it to the owner and the party whom you're privy with, and I would send it to everybody up the contract chain. On a public-private project, that can sometimes be hard to figure out who everybody on that chain is, simply because you don't always know. But you can certainly go to the auditor's website for the county and figure out who the owner is. On a public project, you want to send it to the public owner. That should be easier to do. And again, whomever you're contracting with, then ask for a copy. Not adversarial. Tells everybody we're serious about getting paid, and it makes you a priority to get paid. Those notice of furnishings that we talked about, the notice of furnishing is once again designed to tell people who don't know you're there or might not know a sub's there, we are here and we're performing. It's designed to smoke out and prevent hidden liens so that the opportunity is there throughout the project to make sure that that party is paid and not wait till the end. And it needs to be sent within 21 days of the first work or material supply. Now, you say to yourself, well, we're really responsible. We're going to make sure it gets out. As soon as we sign the contract, we're going to send the notice of furnishing. The problem is there's a stupid case decision out there. A court, I think, got it wrong and said if you send it more than 21 days before you start, it's invalid. So that's really stupid. Just make sure to calendar in your processes to, as soon as you start work, to send the notice of furnishing. And if you're late, a notice of furnishing can always be sent late, but it only goes back in time 21 days. And once again, you send it via certified mail so that we have evidence that it was sent in the event that there's any dispute later on. So on a private job, as I said, a notice of furnishing isn't required if you're a direct privity with the owner, because the owner knows who its general contractor is and probably lists the name on the notice of commencement as well. But if your name's not listed and you don't have a contract, you need to send it. Basically, every sub on a private job needs to send with the exception of the general contractor. Now, if the notice of commencement's not yet recorded, you don't have an obligation to send a notice of furnishing. Our advice, even if there's not a recorded notice of furnishing, send the notice of furnishing to your contracting party, everybody up that chain. Send the notice of furnishing, even if the information's wrong. Because if you get a notice of commencement later on, you can then install it, or you can then correct your notice of furnishing and resend it later on. But what it avoids is the dispute where we can't find the notice of commencement because the name is misspelled or somebody in the recorder's office didn't record it quite right or index it quite right, and it was in fact recorded, but you just didn't find it and you blew your notice of furnishing right, you blew your lien. So always send it as well. It's easier to go to a court and explain, look, we tried, look how, this is why we didn't find it, Your Honor, it's reasonable we didn't find it, but nonetheless, we sent the notice of furnishing. They knew we were there, they should have protected us. Again, who do you send it to? The owner. If the notice of commencement lists an owner's designee, many builders, many schools will list OFCC as the owner's designee. Many owners will list their attorney as their designee or a finance person as their designee because they've never built a building before. So they want somebody else to handle this for them. So not only do you send the notice of furnishing to the owner, but if there's a designee listed on the notice of commencement, send it to them as well. And our advice is to send it to everybody in that contract trade. Draw yourself that tree. Figure out who's on there and make sure that they get it. I do see a question here. So it says, if a sub does not send a notice of furnishing and then disputes payment at or near the end of the project, do they lose entitlement? The answer is if the sub was required to send a notice of furnishing and they fail to do so and there's a valid notice of commencement or recorded notice of commencement, they, on a private job, will have no lien rights. Now, at any point, they can go and record a notice of, serve a notice of furnishing and not record it, and that will get them lien rights, but only for the prior 21 days. I would still rather have a small lien than no lien. So keep that in mind. Okay. Notice of furnishing on a private job. Again, not required if you're in direct privity. It's also not required if the notice of commencement is not available. If it hasn't been recorded, you've asked for it, it hasn't been provided, it's not posted anywhere at the site. And again, I have that same warning in here. You got to be really certain it's not posted or provided, which is why my advice is always send it up the contract stream. And if you are the general contractor and you get these requests for notice of commencement, make sure you send them down timely. Get it and send that notice of commencement down immediately, because if you don't, you've now opened the door for claims against you for failure to provide that. Anyone in the contract chain as well, not that they can hit you with a lien, but they'll argue that they're excused from notice of furnishing, and it opens the door for hidden liens, and that's what you want to avoid. again, so what are some of the dangers if you don't send a correct notice of furnishing? So for example, if you have a copy of the notice of commencement, or if it's recorded and it says that the notice of furnishing needs to go to the owner's designee, and you fail to send it to the owner's designee, you may have waived your lien rights. What we see often is the subcontractor will send the notice of furnishing only to the general contractor it has a contract with. Well, that really doesn't do you any good. The general contractor already knows you're there. They have a contract with you. Failure to send it to the owner at all, invalid lien. On a public job, again, if you don't have a notice of furnishing you're supposed to, you've blown your lien right. The only exception is that on a public job, if your contract is under $30,000, you can make a bond claim, even without a notice of furnishing. The law for public projects is that we protect some of the small players who might not take the time to send a notice of furnishing. So if your contract's under $30,000, you can make a bond claim. So again, this slide, I should pull it out. It's here so that you all know it exists and these exceptions exist. So when don't you need a notice of commencement on a private, when don't you need a notice of furnishing? A, when there's notice of commencement, but again, my advice, always send one regardless. B, on a private project, if you have direct contract with the owner, in that instance, you don't need a notice of commencement. If a general contractor sends a notice of commencement, the owner might scratch their head, why am I getting a notice of commencement? You and I signed a contract. On a private project, if you sent a proper request for a notice of commencement to the owner and you receive no response, in that instance, you also don't have to send a notice of furnishing. But I have that going on right now where someone sent a request for notice of furnishing, request for notice of commencement on a private project. They got no response, but it was recorded, the notice of commencement. So now we're going to have a fight. Were you excused or were you not excused? You got to pay me to fight that. Why pay me to fight that when send a request for the notice of commencement, you don't get it within that 21 days, send a second letter. While we receive no response to a request for notice of commencement, that request is once again repeated. Please send it. Here is our notice of furnishing based on the information we have. In the event we receive a notice of commencement, we'll send a corrected notice of furnishing. Hugs and kisses, subcontractor. Tells them, we are here to make sure we get paid. On a public project, the first tier sub who has a direct contract with a general contractor doesn't need to send the notice of furnishing, because once again, remember that general contractor, the contract with them, has the risk of double payment, so they don't need a notice of furnishing. But subcontractors are the ones who get this confused all the times, and they ought to send the notice of furnishing up the chain. The general won't be offended when they get the notice of furnishing. They'll understand that you're being prudent. Again, remember, the notice of furnishing is designed to smoke out hidden liens. That's why we send it, to let everybody know we're there. So when do you serve the notice of furnishing? As I mentioned, on a private or public, 21 days after you start work, not before. If you're late, you can always do it 21 days, and it looks back. If you get the notice of commencement, so here's an event, right? Let's draw a timeline. You start work here. There's no notice of commencement recorded. You're not obligated to send a notice of furnishing, but here they record a notice of commencement 10 days later. You have no written request to them for the notice of commencement. It's recorded though. You're obligated to check the recorder's office and see if it's recorded. So what does that mean? You want to request it by mail. That way, if they record it, they've got to give it to you. Well, if you want to request it by mail, here, mail, and check online. That's what you need to do, because if it's recorded late and you don't know about it, so it was recorded here 10 days in and you keep working, at day 31 right here, day 31, you've now waived lien right because they recorded it late. So you got to watch for that. On a private project, if you send the request, right, like I said right here, in the mail you send the request and you don't receive a response within 10 days. Now, if you receive no response, you still have 21 days from the date you actually get it to serve the notice of furnishing. If you never get a response, no notice of furnishing is required, but send it anyways. I cannot overemphasize it. Send your notice of furnishing anyways up the contract chain to make sure you don't blow it. Another thing to think about. So here, work started, right? Here's work started. Here's where they did the NOC. on this project. This is where people get themselves in trouble. So here's your NOC. Right here is where work started. Work start. Okay? On this project, lien rights for work here in this portion of time will relate back to first visible work, meaning here, where it says the word work, so that if a mortgage is recorded after work has started, the work that is before the mortgage will prime the mortgage. So what does that practically mean? It means that most title companies, because a title company will give the lender, the private project, title insurance, that lender's mortgage is the first and best lien against the property, the title insurance company will actually send someone out with a camera to the site to take a picture to make sure no work's been done. Because if there's any visible work prior to the mortgage being recorded, that visible work will prime and give the lien claimants rights on top of the lender. And the lender doesn't want that, and the title insurance company who's insuring the lender doesn't want that. So what happens in the event where we know, I've been involved in situations where the private developer has enough money to get started in grading the land, they'll get their construction loan to build the building up. What happens in that event? What happens is either the private developer has to give an indemnity to the title company for the title company to ensure the mortgage is first and best, because what happens is the mortgage gets recorded first, the notice of commencement gets recorded right after that. That way the mortgage is first and liens follow. But in the instance where work starts before the mortgage is recorded, so again, the lien rights will prime some of that. Or what I also have seen and I've worked with clients on is we're going to do two notices of commencement, so we're going to break the project into two. So the first notice of commencement, the first contract is going to be for site improvements. We're going to let a contract for site improvements, and that's it. And the final product of that contract will be the building pad with the improvements on the ground. We're able to then show the lender and the title insurance company, look, we had a contract right here for $600,000 to do the site work and the improvements. Here's evidence of full payment, full $600,000 been paid. Here, that general contractor signed a lien waiver confirming they've been paid every penny of the $600,000. They waive any rights. That project is closed out. Now, you lender, you give me the mortgage for the vertical improvements. We're going to record the mortgage. We're going to record the notice of commencement, and up we're going to go. So if you have a clean break like that, you can do that as well to avoid the problem, because this is a real problem when work starts before the notice of commencement is recorded. Lawyers like me love that because I only represent general contractors and subcontractors. I never really represent owners, because it gives me the ability to tell the lender and the owner, I prime you, I got a lot of power. So why do we file liens? Liens are filed because somebody hasn't paid us. On a public project, the general contractor has a right to file the lien as well to secure itself. On a public project, the general contractor cannot file a lien because it's the general contractor's pot of cash anyway. So the general contractor will simply have to litigate without a lien. We file liens when they're disputed extras. So if we feel we're entitled to money and the owner refuses to pay and we get to the end of the project, we are going to file a lien or any time prior for those extras as well. And I have clients say, Aaron, what can I lien for? How much? And I say, well, we can lien for all work performed, your earned and unpaid retention, even though it's not due and owing yet, and the extras that you've performed work on. Again, it secures payment. It's that powerful bargaining chip. And as I mentioned before, even if there's no equity, when you have a lien, you get a seat at the table and in any litigation. How do we file a lien? Liens on private work have to be filed within 75 days of last work. And what's in the lien? It lists the first and last date of work, how much is due, a description of the property, which we're just going to cut and paste right out of the notice of commencement. It's going to list your name. It's going to list everybody in the contract chain up and down, and it's sworn under oath. So now the question is, when 75 days of last work? Oftentimes we get people who wait. And the first question I ask them, is it punch list work or is it warranty work? Punch list work is considered contract work. If you have a punch list and somebody gives it to you, that's the last day of work for measurement for 75 days of last work. Warranty work is not contract work. And therefore, warranty for warranty, think about it. Warranty, we're done with the contract. We've closed it out. They paid us in full. They call us 6 months later and tell us to fix something. Post-contract, we should have been paid in full. There are times when there'll be overlapping or unclear punch list or warranty work. One of the things I now religiously do is when a client calls me and says, Aaron, here's my date of last work, I ask, give me evidence of that. Most of you, I know who's on this call, you have good daily reports. You can hand me evidence of your date of last work. You know what it is. You've got a daily report. It lists it out. No problem. Some of my less sophisticated clients don't keep daily reports, so the most they have is a payroll record or something. We have found ourselves in the position before when I didn't ask that question, where client gives me date of last work and we pop it in the lien, we record the lien, years later we're in litigation, and the upper tier or the bank challenges that date of last work and say, well, tell me what it was you're doing that day. And we can't find a daily report, we can't find evidence, and that casts a shadow on our liens. So even clients of mine who tell me, Aaron, we don't have a record, so we'll create a true record of what you did that day. You can do it now. Even it's easier to remember what you did last week now than it's going to be 2 years from now to try to figure that out. So you have 75 days on a private project to file a lien. That lien is recorded with the county recorder. That is the key thing for a lien. It is recorded. That way everybody in the world can see it. It is then served, and you have 30 days once it's recorded to serve. Remember, it's got to be served on the owner or their designee. That's the key. Sometimes we see people making a mistake. Served on the owner's designee. You serve it everybody up the chain. Once again, certified mail, return receipt requested. We are in litigation right now where we recorded a lien the day that the title transferred. And so there's a lot of questions on that. Did we do it right? Who do we have to serve? When do we have notice that the title transferred? It's a little bit of a mess. We should have won on summary judgment. The court wants to have a trial on it. So there's all of these issues, and you got to check. And that's why you want to not only rely on the notice of commencement, but be checking in real time who owns the property. Did something change? When you're doing any of these things, we're constantly, my paralegal Shannon is constantly on the recorder's office checking for these things to see if there's been anything updated. Now, filing an attested account claim. An attested account claim, you have 120 days from your date of last work to file an attested account claim. But let's remember, pot of cash. Subcontractor. Fine. Let's remember something, that this pot of cash right here, every time the owner makes a payment from their pot of cash, there's my pot, it goes down. So there's less and less cash. It goes down. Contrast that with the, so here's the notice of commencement and, let's pretend we're painters for a second, okay? So here's a timeline on a private job. On a private job, if the painter's the last person in and they don't get paid and they file a lien, it relates back in time to the notice of commencement. The painter's given the same priority as the excavation contractor, the clearing contractor, the absolute same. But on a public project, up here, public, P-U-B, public, this pot of cash is always going down. So the painting contractor, if they want to put a lien on, if there's some big dispute, there might not be much cash left for them to lien. So you want to do it as soon as possible, because once it's gone, it's gone. Now, don't feel too bad for that painting subcontractor, because there is as well the surety out here. The general contractor has their surety. So even if the general contractor goes out of business and the pot of cash is empty, they can still make claim against surety. I'm going to talk about that in a second. Again, the public lien is served first. You serve a copy of it to the owner or the owner's designee. That is the critical thing to serve, more than recording. It is then also recorded. We record a public lien to give it priority over non-recorded liens. So, for example, if there was a contractor default and the contractor goes out of business and is working on a public project, the owner, that public owner, if a ODOT was involved in a project and it was $1 million project, half was performed, so there's $500,000 of cash left in the pot, contractor goes out of the business. The public owner will say to the surety, you got to step up and fix this. If the surety doesn't, the public owner has first rights to use that $500,000 cash to go hire somebody else to finish it. The surety steps up and finishes. That cash is the surety's collateral, which is why you all see before a public owner will release final cash, especially where there's been liens, they require consent of surety to release that. In the event there were the project's done, but there's still money because of attested account claims, if there's a $500,000 pot of cash, but there's $1 million in liens, of which they're all recorded, then everybody gets 50 cents on the dollar of their liens, paid pro rata. If there was $600,000 of recorded liens and $400,000 of unrecorded liens, that $600,000 of liens would get paid pro rata out of their $500,000. So whatever that percentage is, 70 or 80% of the money on the pennies on the dollar they would get. Recorded gets paid first, pro rata from what's left in the pot, and unrecorded, if there's anything left after that, they get it, and oftentimes they get nothing if there's nothing left. So it is a good idea to record. It's not necessary, but it's a good idea to record the attested account claim as well. So what happens after a lien? This is where we tend to get involved, and I think this stuff's fascinating. So a lien on a private project is an event of default. The lender will find out, hey, there's a lien on this project. The lender will now say, well, you, Mr. General Contractor, Mr. Owner, you need to get rid of that lien. And if the general contractor, especially if the general contractor's lien, is unwilling or unable to bond it off, and we'll talk about that in a second, and that lien sits on there, now the lender says, we're not lending any more money until that lien is gone. So the lender's not lending, the owner's not getting the money, the owner can't pay the general can't pay the subs. What happens? More liens go on. It becomes a nasty cycle till the project shuts down because nobody's getting paid. And then we got to go to court sometimes and get it cleaned up. So a private owner who doesn't very quickly take care of liens, especially where there's a lender in place, is going to find themselves in trouble. Again, this goes back to my first slide we talked about. Where's the money coming from, right? Jerry, show me the money. On a private project, is it coming from a lender? A lot of projects we all do today, I know some of you have been on these public-private projects. We don't know who the hell's a lien anymore. You were working on the queue. Who do you lien over there? We have a project on a shopping center where the public owner gave money for some of the parking garages. So the subcontractor filed a public lien and a private lien because it's not really clear on these public-private partnerships. This is the future, these public-private partnerships, especially now as the economy starts to shrink down and cities want and governments want things to happen again. They're going to put money in, and you're going to have to do both type of liens. So you've got to watch for that. As I say, sophisticated clients lien both. So at the lower tier, you've got to investigate and know how you're going to get paid. Again, what are some of the risks? There's a single asset entity on a high-risk project. You got to know this is the only thing they have, and if it doesn't go well, remember the term we had in 2008, jingle mail? Put your keys in the mail and mail them to the bank. They're going to let it go. Pay if paid as well. I know most of you on the call are my clients, and when you put the pay if paid provisions in to protect yourself from an upper tier default so you don't have to pay the lower tiers. If you're a subcontractor, that becomes more of an issue. But as a general contractor, you want pay if paid provisions because they protect you from having to pay when you don't get paid. So again, we've talked about what's the purpose of lien law? To smoke out hidden liens. It permits the owner and the general to make sure everybody down the title chain is getting paid. Step one, if you're an owner, got to do the notice of commencement. It needs to be drafted and recorded before work starts, ideally after the mortgage. The law is that if a mortgage and notice of commencement are recorded on the same day, the law deems the mortgage recorded first. The law acknowledges that a county recorder might have a clerk who gets it wrong, ignores it in a direction, and doesn't want to have a bunch of litigation where the notice of commencement got recorded first. If it's a few days before, now you got a big problem, and the title company is going to require an indemnity, and it gets messy. On a private project again, so let's go through some of these. No notice of commencement if the lien, so if there's no notice of commencement, I said before, the lien relates back in time to first visible work. Here's a fun case, this Huntington National Bank case. The lender and borrower executed the loan agreement, recorded the mortgage and the notice of commencement. And this is, again, a law I just mentioned. If the mortgage and notice of commencement are recorded the same day, the mortgage is always considered recorded first. Here, the lien claimant recorded a lien that claimed a date of first work before the mortgage. and notice of commencement. They said they were there first. That would give them priority. So let's look at the law on that. If a notice of commencement is recorded late, and that's 1311.13A1, any work before the notice of commencement, I said, relates back to first visible work. After, so if you record it in the middle, it relates back to notice of commencement. So if you were to file a lien, the court would look at your lien, here's your lien, and they'd break it up. They draw a line and say, okay, this part up here, this primes the mortgage. The part that is before the notice of commencement. I should get the text tool, but that primes the mortgage up here. But this part down here is junior to the mortgage. So the mortgage would get paid first. So if we were to foreclose, the order of payment would be up here. This would be paid first. The mortgage, where's the mortgage? Wherever the mortgage is going to get paid second. And then down here, the junior part of the lien gets paid third. So if it's both, as I say, if you have worked both before and after, the law is that the payments get applied first to the pre-notice of commencement work. Why is that? Again, the law wants to protect lenders. The law knows that if we don't protect lenders when they lend on projects, if it's too easy for lien claimants to prime a mortgage, the lenders are going to not be willing to lend. So we need to protect the lenders. We need to protect contractors as well, but just understand that's why the law is how it is. Now, here, Huntington Bank won the battle. Remember, it was a battle between this lien claimant right here who said that their first result work here, the mortgage was recorded on December 23rd. The lien claimant recorded a lien 7 days later and claimed that their first date of work was a year prior. So they claim that they were over a year before the mortgage was recorded, and that would give them priority, but they lost. How did they lose? So the court found that the work secured by the lien was really done after the notice of commencement was recorded. So here, if you get in litigation like that, they're going to want to see your daily reports. They're going to see your record. So that begs the question, if the work was done in 2012, how the heck did they record a lien in 2011? The court said that the lien didn't say it was securing amounts due from that 2010 date. The lien claimant account receivable report showed the work starting on that date. So that's part of the problem. And this is why you want to have consistent documents here, because their own document showed that the work that was being liened was from 2012 and that they were paid in full for all work. The court found that they didn't prime. So if you're going to do this, you got to make sure that your stuff is compatible. We're at 1048. And I've talked about this as well, what happens when a lien is recorded or primes a mortgage, and the fact that the title company will require indemnity. So we're not going to go through that again. When you record a lien is good for 6 years. It says a notice of commencement also requires after 6 years. I don't know of any projects in Ohio that take 6 years. Again, we talked about the notice of furnishing. You serve it to everybody up the contract chain. The people who get the notice of furnishings need to make sure that if you get it, that everybody down the chain is paid. You got to track that to make sure that if you're paying this person here, that you have waivers from everybody down the chain to the extent of prior payment. That will make sure that your risk is limited to 1 month only. So here, a lender as well. A lender on a private project is going to look for the title company to confirm for them that lien waivers are all in place. When a good lender is going to have somebody out there making sure all of this is done. So again, if there's no payment, we're talking about a lien recorded. Here are the key dates. 75 days on a private project from last work, you have to record a lien. If it's a residential project, and I don't think any of you do residential construction, it's 120 days. But 120 days oil lien, but let's jump back to residential. What happens if you get hired to put in a brand new subdivision, a 100-acre subdivision? I bet some of you would put in streets and roads and utilities for a 100-acre subdivision. I know you would. And then suddenly you go put those in and they go record a plat, right? The plat that breaks that up into streets and lots. Well, arguably, you now would have a lien on every one of those residential homes. What a pain in the butt that would be. But you will also arguably only have 60 days to get that on. So watch that. Another thing to think about. And again, I don't think any of you do work on small projects with the leasehold, but if you were to do work on a lease, for example, you want to go fix the gap in Beechwood Place Mall and you have a contract with the gap, Your right is only to lien the leasehold, not the entire mall. So watch out for that. You can't lien, as you guys know, the road, the school, or publicly owned building, so that's why we lien the pot of cash, and it's always going down. Notice of commencement we've talked about, notice of furnishing, everybody up the contract chain. We know that, again, I can't emphasize this enough, the general contractor has the risk of double payment. So they're the ones who need to make sure everybody's getting paid. The owner doesn't even care. When an owner or public owner gets a notice of furnishing, they stick it in the drawer, they don't even look at it. And again, if you don't do a notice of furnishing, you waive your lien right. But if your contract's under $30,000, you still have a bond right. What we've seen are people say, well, I'm only going to make a $30,000 bond claim. Doesn't work. If your contract exceeds $30,000, you waive that right. Again, on a public project, the general contractor has to ensure payment to everybody downstream, just like you do on a private project, right? Here's your GC. You got to make sure all those people, you can check the box every month, are getting paid. If they're not paid, they're going to file that attested account claim. So what happens when you get an attested account claim gets filed? So let's jump to step 4 and step 5. Step 4, somebody files an attested account claim. The public owner, when they get that attested account claim, will send the general contractor notice. We received this. Do you dispute it? If a general contractor doesn't dispute it, they have 20 days to do it. If they do, then the public owner is going to hold that pot of money indefinitely until one of two things happen. Either the general and the lien claimant agree on how it can be released, or a court determines how it can be released. Otherwise, it will sit there indefinitely. If the general contractor or sub does not dispute it, after 20 days, the public owner can release the money to the lien claimant. We have, on behalf of lien claimants before, sent in liens to ODOT. And when we serve our liens, we say, hey, ODOT, here's our lien. Further, we're copying the general contractor, and per 1311.31, what I'm circling right there, we are giving notice that the general contractor has 20 days to dispute. When the general contractor doesn't dispute within 21 days, we've sent letters to ODOT. Dear ODOT, they didn't dispute it. They've assented to the correctness. We need to get paid, and we've had ODOT release cash to our clients on that basis. Again, public-private project, this is the new reality. The Port Authority money is all over the place, even on buildings that look public. Just outside my office window is the new Beacon apartment complex. Privately owned, I think Stark was a developer along with the Dessler family, but there's public money in there. So what does that mean? It means you had to do both a lien and an attested account claim. And it also means that if you have an obligation to bond it off, it's got to be bonded off twice. How do you remove liens? And I know our time here is limited, but I'll just talk about this quickly. On a public project or on a private project, you get a bond. And the bond, if it's over $5,000, it should say 5,000, not 45. It's for 150% of the lien amount. You then take that bond, you apply to court and say, court, I want you to take the lien off of the private building, and I want you to stick it on my bond, and a court will do that. The only hearing that should go on in that instance is on whether the bond is adequate. And any of you who are getting a bond from a nationally known surety, the bond is adequate and there shouldn't be any issue. The law is written that way because back in the day, you could bring 10 cows to the public square and say, hey, these 10 cows are adequate security for this. We've had courts as well, I think wrongly, permit only 100% cash be deposited with the court instead of a bond. What happens sometimes is this hearing, any lawyer who understands what's going on will waive a hearing if the bond's from a national surety. What happens is you're going to get a pro se claimant who thinks that if I'm waiving a hearing, I'm waiving a hearing on my right to my entitlement under the lien. Again, that hearing, because it's just supposed to be a fast process, has nothing to do with whether the lien is valid and whether you're due and owing the money. It's only on whether the bond is adequate or not. And so anybody sophisticated will be able to waive that. Just like a lien, the bond remains in place for 6 years. Somebody, if there's a bond, they'd have to file a foreclosure suit, and instead of naming the owner, they would name the surety. What's the benefit of that for a claimant? If suddenly for the lien claimant, if there was a mortgage ahead of you and the chain and there was no equity, that issue goes away. That's great. Now you have a bond. Who cares about equity anymore? If the general contractor goes out of business, you get paid. What are some of the challenges? Not everybody has bonding capacity to be able to bond off a loan. or bond off a lien, pardon me. Sureties is all of you on this call, I know, because you're all bondable and have lines of credit with sureties. They do a financial audit to make sure somebody has the capacity to pay back in the event that there's a claim against them. Otherwise, you can deposit cash. What's the benefit of bonding it off? If there's a disputed lien, remember we had that slide before that says when a lien isn't paid or it sits on a project that's going to slow payment from the lender, it gets rid of that. You can also send a notice to commence suit. I have one right now where somebody on a $40,000 lien sent me a notice to commence suit, and I told them, you go make me commence suit, I'm going to want my attorney's fees. They sent it anyways, and we filed suit, and our lien remains, and they're going to have to pay my insurance, my attorney's fee if they want to get it resolved. A title company can insure over a lien. So if there's a lien there, you might be able to say to the title company, look, there's a $15,000 lien. It's small. Let me give you $15,000. Tell the lender that you'll insure over it. Don't make me remove it right now, and sometimes that will work. On a public project, to get rid of a lien or to bond off a lien, you've got to do two things. First, you give a copy of a bond on 150% to the public owner, and you send the lien claimant a notice to commence suit. As soon as that goes to the public owner, the lien is released as against the pot of cash and is now on the bond. The lien claimant then has 60 days to file suit. If they don't, the bond is released. One thing we see sometimes are we will say to a lien claimant, look, we're going to give a bond to the public owner. Tell the public owner they can pay us. You still have the bond. Don't make us send you the notice to commence suit, because maybe we'll get to the end of the project and be able to get this done. And we've seen lien claimants and public owners have to do that. We know that in arbitration, you can't foreclose on a lien in arbitration, but most of your contracts have arbitration in there. We're fans of arbitration. We think it's faster and cheaper, although we do see some discovery creeping in there that we have to push back on. If you have a notice of commence suit and you have a arbitration provision, you still have to commence litigation. You don't get to just commence arbitration. That probably won't do it. What we'll do is we'll file suit and we'll file a demand for arbitration at the same time, and then we'll agree to stay the litigation pending the outcome of arbitration. Payment bond claims in Ohio, I want to hit this really quickly. I know I have 2 minutes. These must be made within 90 days of project acceptance. This is only on public project. You send a letter to the surety saying, we make a claim, here's what it is. You then have to wait 60 days, 60-day cool-off period before you can file suit, and you must file suit within 1 year. So those are the time frames to think about. I guess I drove right up 58 minutes. Are there any questions? If there are, you're welcome to unmute yourself, or you could type them in. Well, if there are no questions, I thank everybody for oops, please. Well, I think that was probably Chris who unmuted himself. In that case, I do want to thank everybody for participating today. I hope this is helpful. We are happy to come and do this presentation again for OCA members at no charge. I'll come in, do this in your office with a whiteboard. I'll wear a mask, we'll socially distance, and we'll explain to make sure your accounting staff understands all of this. I hope this was helpful. I want to thank Chris. I want to thank Aaron Hawk. I want to thank Ohio Contractors Association for giving us multiple opportunities to present to your members. We appreciate it very much. And Chris, I'll let you finish up, but thanks everybody. Have a great weekend.
Well, thanks, Aaron. Really appreciate it. And I know we'll be doing more of these in the future as we move forward. So
we're
everybody,
happy to do them anytime.
Very good. Have a safe and good a long weekend here, Memorial Day, Thanksgiving, I don't know.
They all rise together. God forbid we're home at Thanksgiving.
All right, everybody. Have a great weekend and be safe.